What shall we say? And goes hello. And I know we say, thank you, Lord. What shall we say? And goes hello. And I know we say, thank you, Lord. 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 Thank you, Sakota. And I know we say, thank you, Lord. Well, when you have the word cup, I want to bring to you a good news. Wallahi. If you know you are from America, you are from Nigeria, you are from Africa, you are with the money according to your temper. If you not go even there for your time, go even. If you not go there, come on, good night. Wallahi, what has bring us what you call it, a lawyer for having a combo to the news channel TV. The one they give us like secret scandal on how we're going to win the election. Well, I tell you, so no one understand. We are going to watch the video. You know, after the victory of the Osun State Governor, Adeleke, I tell you, I will drop the video. You will see some other video, clip of it. I can't go. No, because my concentration is on Obi. Now, the ones that want to say, after they don't win the election because of the help of BVAS, you want to analyze how the BVAS will help us. You know, these people, the things we don't get house, we don't have sense. Now they are requesting to borrow $80 million US. How many days remember for them they will go? They just signed a contract $60 billion US. Commanded for yesterday. How many days remember for them to go? Well, you know, you know, that contract. You want to collect our money around. Like I said, their ministry is continuation. Continue to kill you. And like I always tell you, subscribe to my channel. Like, comment what you think about the video that you are going to watch. I want you just watch the video. Don't skip anyone, man. Watch to the end and make sure you comment. Can you go? Thank you, Lord. Thank you.
Yesterday upheld the judgment of the Court of Appeal in the case involving Ademola Adeleke, the governor of Osun State, and Boyega Oyetola. The Apex Court affirmed Adeleke as a duly elected governor of the state, stating that it is glaring. This is part of some of the statements made by the lead judge in that proceeding. He says it is glaring that the appellants could not prove overvoting. He also went further to say it is the record in the BVAS machines that can prove the number of accredited voters in a polling unit and nothing else. Let's make sense of it. Because, of course, you know that apart from the bodies of our laws, the Constitution, the electoral law, whatever is being said, especially by the Supreme Court, is law also. It becomes a precedent and is very relevant. And so, what are the implications of the Supreme Court judgment of yesterday? Don't forget, this is the very first test of the Electoral Law 2022, and it has a huge implication. Let's get talking. I have someone with a depth of experience, not only of knowledge, but of understanding and history of understanding of institution, Mr. Oluwole Osazi, who's a very senior lawyer and a former director of voter education with INEC. Thank you so much indeed for coming tonight.
Thank you for having me. Good evening.
You came to mind yesterday when that Supreme Court judgment was coming on, and I thought, wow, we had a lot of conversation about the electoral law and what it means for our future elections, especially 2023 elections, without having to talk about what is happening at the tribunal, because the judgment of yesterday has a huge implication of this particular matter. But let's dwell on what we know and the facts of what has been delivered. This is, we do not have the details of the Supreme Court judgment just yet.
It's not yet out.
But we can extrapolate based on what my Lord Justice Agim said yesterday. He was the lead judge. And let's look at what he said. These are some of the excerpts, and I have some quotes from him. He says, it is glaring that the appellants could not prove overvoting. Right. That's one of those statements. He also said in that judgment, it is the record in the BVAS machines that can prove the number of accredited voters in a polling unit and nothing else. He also said, the appellant had a primary burden to prove the fact asserted by them in their petition. It is obvious that the appellant's case collapsed. He also said, no evidence was adduced to prove the case of forgery against Adeleke. In the absence of such evidence, the allegation is not proved beyond reasonable doubt. He went further to say that the entire proceedings of the tribunal remain a nullity. He now affirms that on the whole, this appeal fails and it is hereby dismissed. And I dare say the appeal judgment, the Court of Appeal judgment was upheld, which means that there is a relevance of the Court of Appeal judgment, which I've tried to summarize tonight, which we would like you to give perspectives on. But give me an understanding. Some of the statements from the learned judge, honorable judges yesterday, yes, it was a unanimous one from
Correct.
all of the 5 of them.
Correct, it was. We have to be careful when we are doing an analysis of the judgment because the full reasons for the judgment have not been released yet. But we've spoken to people who were in the court, in the Supreme Court, and who listened to the judgment and who took some notes. So let people know that we are speaking contextually and from what we heard and the records that we have for now in the public domain. Yes, I like the excerpts that you have taken out of that leading judgment. For example, let's take this. It's glaring that the appellants could not prove overvoting. Now, the duty of the petitioner is the duty of the petitioner, and the burden rests on the petitioner to prove his case in the tribunal. If he fails to prove the case, then obviously the election will stand. So he must discharge that burden. And from what was available, that burden was not discharged. Let's take overvoting, for example. They relied on certain exhibits which were certified through copies of the download from the IREV. But the minority judgment in the tribunal said, look, the BVAS machines are here. Rather than take extracts from another platform, let us look at the BVAS machines. It's the BVAS machines that will determine whether there's overvoting or not. Don't forget the definition of overvoting, where the total number of accredited voters, the total number of votes exceeds the total number of accredited voters. That was one of the changes in the new Electoral Act, as we had discussed severally on your program. So having a look at it, the BVAS machine accredits people. It is the device you use for accreditation. So, and automatically it stores the number of people it has accredited. Unfortunately, the majority of the tribunal, now the null judgment, said, look, we will look at this certified true copies given by INEC to the APC as it was that time. They said, no, you shouldn't do that when the machine itself, which is the primary evidence, is before the tribunal. Use that machine. That is the only one that can tell us. Because INEC argued that, well, by the time they uploaded these things, some data was lost, it has not been synchronized. I think that's the word that was used, it has not been synchronized. But good, deal away with those things. Let us see the BVAS machines, the original machines which did the recording. You look at them and look at the total number of accredited voters in those machines. The day the votes exceed the total number accredited, Supreme Court and the Court of Appeal said no, it did not, and Supreme Court have validated that judgment of the Court of Appeal, and rightly so. If we must state that.
As a rider to that,
yes.
Mr. Alh.Suleiman, this is what the Supreme Court said.
Yes.
It is a record in the BVAS machines that can prove the number of accredited voters in a polling unit and nothing else.
Absolutely. That is what the Electoral Act.
Where does it leave IREV?
Look, IREV does not give you the total number of accredited voters. IREV gives you the results. Admittedly, the presiding officer takes the total number of accredited voters that he reads from the BVAS and endorses it in the IREV. It's a human thing. Whereas the BVAS automatically records the total number of accredited voters. It automatically accredits people and records the total numbers. It does not record votes. But the votes as manually filled in is stored in the BVAS and it uploads to the IREV. So it's complementary. What you see in the IREV as the total number of accredited voters should correspond with the total number of accredited voters as recorded automatically by the BVAS machine.
And that is also prevailing in the third prayer in the Court of Appeal judgment.
Yes.
And so this is because basically the Supreme Court upheld the position of the Court of Appeal.
Yes.
And part of the second prayer, the pleading at the Court of Appeal, which Adeleke went to appeal, was that on the issue 3, the question that arose for consideration is whether exhibits SCH1, SCH2, 3, and BVR, that is certified true copies of the forms EC8, A, B, C, D, and E ought to have been admitted in view of the fact that the receipt issued for their certification postdate the said certification. The court found and held that while the payment of legal fees and evidence of same is an integral part of the certification process, the fact that the receipt of payment was only issued after the certification does not ipso facto render the said public document inadmissible. Issue 3 resolved against the appellant. Can you make sense of that for us?
Well, I think the issue was raised. There was a certification of these result sheets. Yes, a certification, and it was tendered in evidence. Now, when you tender evidence these days, when you tender a certified true copy, you should also show evidence that you paid for the certification of those documents as approved by the issuing authority. So INEC charges you, it's a minimum fee, INEC charges you for certification of each document. Now, when you try to tender these two, you must tender the two together. You must tender the certified true copy of the document you certified as well as the receipt, evidence of payment. So the heavy weather was made of the fact that, the receipts came after the certification, whereas it should precede certification. It should pay before the thing is certified. In practice, different institutions do things differently. What is important is that the certification was paid for.
So it's a procedural issue.
It's a procedural issue. It didn't affect the substance. But they were trying to make it an issue of admissibility. But the Supreme Court said no. You as long as there's evidence that has been paid for, whether it postdated or predated, that should not make too much of it. It's a technical procedural issue. All we need is that evidence that yes, you applied for certification, you paid for that certification, money went into government coffers, and this is the document that was certified for you.
Thank you for clearing that with us. Yes. So let's go to this issue 5. Which is part of the issue of overvoting that you talked about. This was a position of the Court of Appeal, upheld by the Supreme Court, as was declared yesterday. And basically what you said, I mean, the issue is 5 and 7 were considered together, and the issues raised were whether the petitioners, now respondent, proved overvoting, and whether the trial tribunal was right to have relied on the table supplied by the petitioners to reach a verdict that they provided of overvoting. The Court of Appeal found and held that on the issue of overvoting, the information on the physical BVAS machine supersedes that of the back-end report issued by INEC and which the petitioners relied on. The penultimate court also found that Section 137 of the Electoral Act does not displace the need for the petitioner to still call oral evidence of polling unit agents who operated BVAS machines in the disputed unit. It went further to say the Court of Appeal ultimately found that the tribunal was wrong to have reached a conclusion on overvoting based on the content of the table presented by the petitioner and also exhibit VVR, which ought to have been demonstrated in open court. Issues 5 and 7 were therefore resolved and in favor of the appellant. That's Senator Adeleke.
Yes, correct. Again, these are some technical procedural issues which I'm happy you're bringing them to the fore. It has to be broken down so that people understand this issue. You can have a fantastic case, but if you don't go by these procedural steps, then you might have problems in the tribunal. It can apply to either the petitioner or the respondent. Now, the petitioners came to court. Oyetola came to court and they look, no, we have an expert, and this expert has analyzed all the data and presented a table of the data. And the tribunal fell into error in relying heavily on that table, which in one sense, the lawyers will understand this is secondary evidence. It was an extrapolated from something else, an extract from another, from the BVAS, from the reports and things. They say, no, the BVAS machine is there. Let us see the printout from the BVAS machines. Rather than rely on this so-called expert, we or anybody can look at the BVAS machines, record the numbers that is there. And it's not enough for you to come and tender these things. People who operated the BVAS have to be there. Documents, to an extent, speak for themselves. But you need to tie those documents. You need some oral evidence to hang those documents and say, look, this is this. We were this polling unit, and this happened, that happened. And some lawyers felt that the new Section 137 of the Evidence Act had relieved witnesses of the burden, or petitioners or respondents of the burden of proving things once you just tender those documents. But from the decisions of the Court of Appeal and the Supreme Court, the documents don't necessarily speak for themselves. There must be some oral evidence tying them and explaining their contents. They don't always speak for themselves. That is my understanding of that part of the judgment.
If you look at all of about the 8 prayers that was taken to the Court of Appeal, the issue of the BVAS is very evident. There's a big lesson that all of us need to learn from the position of the Supreme Court on this issue of BVAS, and it takes me right back into the statement, which for me it's yeah, of course, the issue of this is it. Yes, this is it. It is a record in the BVAS machine that can prove the number of accredited voters in the polling unit and nothing else. What lesson do you think everyone, politicians, lawyers, need to avert their mind to, and in fact, Nigerians at large, about the electoral law and our election from this?
Well, the Electoral Act, one of the innovations was that you use the smart card reader or any other technological device. And hanging on that, any other technology device, INEC introduced the BVAS. Now, the BVAS, what it does is record the total number of accredits you, of course. And in the process of accrediting you, either through your facial recognition or through your fingerprints, it records it that, look, Mr. Sean has come to vote. That is one. If Mr. Z comes, that's 2. If Mr. David comes, that's 3. It records the total number of people who have come for accreditation. Having come for accreditation, the ballots cannot exceed, not even by 1. If it exceeds by 1, the act says, no, go back, there's something wrong, because automatically the BVAS has recorded and stored this thing. So don't give any chat by anybody else. Sometimes the back end might be faulty. The main thing is that it is this machine that has recorded these things, each machine for each polling unit, bring them. And in Alh.Suleiman, they brought them to the tribunal.
If I prove overvoting, what happens?
Now, first of all, before you get to that stage, if INEC realizes, the presiding officer realizes there has been overvoting, when he's entering the results, because first of all, the first thing he does, both the presiding officer and the collection officer, the first thing is to look at the, go back to the BVAS machine, record the total number of accredited voters first, and then you count the ballot papers. If the ballot papers exceed, the votes exceed, you cancel that result. And if it has a bearing on, ultimately, on the overall results, then you go back and conduct elections.
At what point do you reconcile the record on the BVAS? Because, I mean, it's understandable that there are some times that all of what is on the BVAS does not go up, or is not fully recorded, or is not reconciled with INEC owns record because of internet and connection issues.
Yeah, but first of all, it records it there.
Physically speaking.
Physically, it records it there. So that's the first port of call. The presiding officer ought to check that, because he's going to take the number accredited by the BVAS and endorse it into the EC8A, into the result sheet. That's the first thing he does. He will ensure it does that total number of accredited voters. There's a column for that. He records it there. The agents have to take note of that, party agents, and also at the first and every stage of collation. At the collection center, the first thing the returning of the collection officer does is to look at the BVAS and confirm, that's what the act says, confirm that the total number of accredited voters as recorded by the BVAS and transmitted is correct. So it physically checks the BVAS and confirms the correctness before going into the scores and confirming that with the IREV. It's the scores you confirm with the IREV, the total number of registered voters you confirm from the BVAS itself.
Mr. Oluwole, tonight, if there's something that we have learned from the Supreme Court's judgment, which in some way, technically and fundamentally, impacts on the electoral law and our electoral process, what would that be?
The importance of the BVAS in the process, the importance of technology in the process. And this has a bearing on the three, I think, presidential petitions, that of the LP, Labour Party, or the PDP, and I think the APM, so the 3 remaining petitions. It has a bearing in that regards. But the twist in the presidential petitions now is the fact that the IREV, which was not an issue in this one. So in certain regards, out of the 8 issues, I think 2 or 3 have bearing on not just the presidential, but of course on the overall electoral process and all the petitions that have been filed in this matter. The importance is central. That look, you must be careful about this central role that the BVAS plays. And the Electoral Act has come. This is the first time Supreme Court has put a stamp on some of the novel provisions of the Act. So the lawyers are going to sit down, study the judgment. We hope the judgment comes in the next few days, the full judgment.
Yeah.
We're going to study, dissect it, and see what bearing it has on all the cases and going forward on the operations of the Electoral Act.
I bet you that my Lord Justice, judges at the Court of Appeal will also be studying, all the lawyers will be studying to become something like an appendix to the electoral law for almost everyone. And in fact, eyes will be on some of these statements, which should now be very fundamental and crucial going forward into our electoral process.
Absolutely.
Thank you so much indeed, Mr. Oluwole Osaziuzi, a very senior lawyer and the former director of voter education. You've been a lot of former.
Well,
in
you brought me here to discuss law, so former director of legal services.
Legal services.
Water run away me I, water run away me so. Water run away my eyes. Great Nigeria youth. So what we are calling the judiciary this afternoon is that the judiciary must allow our votes to count. We want that the judiciary to be fair. We are not against anybody, but we want the judiciary to do the needful, that our votes will count. So we are calling on the judiciary that they should dispense justice without fear or favor. They should dispense their justice without any money bags. We want Nigeria to be free. That is all what we are calling for. Thank you very much. Thank you. Let's divide our...
Muna duka malaka mu duka school makarantu mu a daji ba ma zuwa mun ayi hakuri Mahmudu ya yi hakuri ya fada.
To ask the judiciary to do the needful. What is the needful? To give us sound judgment at the end of the case.
Yes.
We don't want the president of Nigeria to poke nose in the judgment. Not be so? No. President Muhammadu Buhari has finished his tenure. Let him excuse Nigeria. Yes. It is the Nigeria's people's property. Yes. That is why we are here. We are here to tell the judiciary to help us save our democracy. Yes. Any altar of fake judgment given on this case will tear Nigeria apart. Yes. And we are begging the judiciary to do the right thing. Yes. Give us sound justice. Thank you for coming. And in the next court case, we shall surely be here. Okay, then please, so that Yusuf will wrap up.
Yeah, we thank you all for coming. We have made you understand that judiciary is on trial.
Yes.
Because they are the last hope of the common people. Now they are on trial. Why are they on trial? Because in recent past, judiciary have been accused of giving wrong judgment. Therefore, they must be at this point in right standing. If they are in right standing, they will bring peace to Nigeria.
That's right.
They will bring unity to Nigeria, and unity will project progress. So we are telling the judiciary to please do the right thing. Thank you.
Okay, so finally I will emphasize what I have said earlier. At this time around, it's not about any party or any candidate. Yes. It is the Nigerian people that contested the election, and the Nigerian people won, and somebody wants to steal our mandate. Will we let that happen? No! That is why we are here, and we will not settle until our mandate is given.
Gentlemen!
Yes!
Gentlemen!
Yes!
Everybody here is a man.